Hello, we're Sara Hunton and Francis Wilkinson, barristers at Field Court Chambers. We wrote the first edition of Costs in Family Proceedings, and the second edition is now being launched. Sara, what has been the effect of the Law Commission's report on the enforcement of orders in family proceedings?
Well, the Law Commission wrote their report in 2016, and in that report they recommended that the procedural rules needed to be simplified and consolidated. At that time, they are some within the family procedure rules and some within the civil procedure rules. They also said that guidance for litigators should be improved and that there should be increased duties on debtors to disclose their financial position. They noted that the court lacked powers to catch all of the assets that a debtor might hold, and also that the court could do with more information about the debtor's position so that they were able to consider the enforcement. And then finally, they recommended the use of coercive orders, such as preventing a judgment debtor with an outstanding debt, preventing them from driving or leaving the jurisdiction. The government responded to this in 2018 and then again in a briefing paper in January 2019, and they agreed with the points that were raised, in as much as that they saw that the system was open to exploitation by debtors who simply chose not to pay although they could afford to. At the same time, they noted that because that there may be situations where the debtor simply couldn't afford to pay because circumstances had changed. And particularly with periodical payments, because those payments may stretch over many years, it may well be that the person refusing to pay, their circumstances have improved greatly over that time, and there would be no reason whatsoever for the breach of the order. The government decided that they would be happy to take forward any recommendations that didn't involve primary legislation. But at the point in January of 2019, they hadn't decided whether it was appropriate to implement statutory reforms. So it is possible to improve the procedural rules and to avoid the adoption from the FPR and CPR rules. A little of that has been done. It would also be possible to improve court forms to improve the quality of information about the debtor's circumstances and to make it clear to them that if they fail to disclose properly and completely, then there will be penalties. But very little progress has been made. Part 39 of the FPR now deals with attachment of earnings orders in respect to maintenance orders only. And Part 40 is a new part which deals with charging orders. But apart from that, practitioners are left with looking at Part 33, which refers to the CPR for most other methods of enforcement.